In this video, we're going to be continuing our discussion about trustee powers, and so far in the previous videos, we've looked at the trustee's power to invest and the trustee's power of maintenance or to maintain. And in this video, we're going to be looking at the trustee power of advancement. So this allows trustees to pay or apply capital for the benefit of a beneficiary, even though the latter is an infant or merely has a future or contingent interest. As with maintenance, the power may be created expressly, or trustees may rely on the statutory power in the Trustee Act 1925, section 32, unless that power is excluded by the trust instrument. So here we are talking about capital, and this is the big difference between maintenance, which is to do with income, and advancement, which is to do with capital. So if we're talking about income, you know we're talking about maintenance, and if we're talking about capital, you know we're talking about advancement. So the power of advancement refers to the power in the trustees to advance capital to a beneficiary, that is, to pay out amounts of capital rather than holding them intact to generate income. For trusts created before the 1st of October 2014 by Section 32 of the 1925 Act, where a person has an interest in trust capital, then the trustees may advance up to 1/2 of the trust capital to that person for their advancement or benefit. But for trustees created since the 1st of October 2014, the trustees may advance an amount up to the beneficiary's presumptive interest. They are not limited to half their share. They may also transfer the property to another trust. So since October 2014, they are no longer limited to only advancing half of the trust capital. It is of the discretion of the trustees to determine what amount is necessary. They can also use this, as we will see in a bit, to get around the rule against perpetuities. So what does section 32 say? The power of advancement. Trustees may at any time or times pay or apply any capital money subject to a trust, or transfer or apply any property forming part of the capital of the trust property for the advancement or benefit in such a manner as they may, in their absolute discretion, think fit, of any person entitled to the capital of the trust property or of any share thereof, whether absolutely or contingently on his attaining any specified age, or on the occurrence of any other event, or subject to a gift over on his death under any specified age, or on the occurrence of any other event, and whether in possession or remainder or reversion, and such payment, transfer or application may be made, notwithstanding that the interest of such person is liable to be defeated by the exercise of a power of appointment or revocation, or to be diminished by the increase of the class to which he belongs. Now that is extremely wordy, but this basically just says you have the power to make an advancement which is at the discretion of the trustee. That's all that's really saying to us. Now, the trustee can make an advancement provided that property, including any money so paid, transferred or applied for the advancement or benefit of any person, must not altogether represent more than the presumptive or vested share or interest of that person in the trust property. So this says that the trustees must not advance more than the beneficiary's whole presumptive or vested share or interest. So previously, before October 2014, the trustees could not advance more than half the beneficiary's presumptive interest. And we've also provided that if that person is or becomes absolutely and indefeasibly entitled to a share in the trust property, the money or other property so paid, transferred or applied shall be brought into account as part of such share. So what this point B means that if you get an advancement and are later due a distribution, they will subtract that advancement you got previously from the current distribution. So if you are owed £50,000 when you are 25, but at the age of 22, you got £25,000 in the form of an advancement, at 25, you will only get £25,000. So they will take into account previous advancements for your future distributions. And thirdly, provides that no such payment or application shall be made so as to prejudice any person entitled to any prior life or other interest, whether vested or contingent in the money paid or applied, unless such person is in existence and of full age and consents in writing to such payment or application. So if we have primary beneficiaries and remainder beneficiaries, if a remainder beneficiary asks for an advancement, this cannot be done if it would detriment the primary beneficiary. So the ones first in line will have priority. And then we got the final section, subsection 1a. In exercise of the foregoing power, trustees may pay, transfer, or apply money or other property on the basis express or implied that it shall be treated as a proportionate part of the capital out of which it was paid, transferred, or applied for the purpose of bringing it into account in accordance with proviso B to subsection 1 of this section. So you have this power and you have this ability. That's all this is saying as a trustee. Okay, you have the power to advance. So let's have a look at a case here, Taylor and Taylor. And in this case, Jessel said that I have always understood that an advancement by way of portion is something given by the parent to establish the child in life, or to make what is called a provision for him, not a mere casual payment of this kind. You may make the provision by way of marriage portion, on the marriage of the child. You may make it on putting him into a profession or business in a variety of ways. You may pay for a commission, you may buy him the goodwill of the business and give him stock in trade. So this case says you don't give an advancement simply because you feel like it, but you have to have a reason behind it and must benefit the beneficiary. Now, there are various ways you can benefit the beneficiary. You can help them get an education, you can help them start a business, you can help them get married, etc. So this is saying that the advancement must be beneficial. And Jessel here is saying that there are some different ways that advancements were made and can be made to benefit the beneficiary. And here are some more examples of where advancements were made to benefit the beneficiary. So in this top case here, we have an advancement was made to finance a career at the bar. We've also had advancements made to pay debts, advancements made to buy a house as a surgery, advancements made to pay school fees, and advancements made to buy shares in a family company. So there are different ways which advancements have been made for some particular benefit to the beneficiary. So let's look at another case here. We've got Clore's Settlement Trust from 1966. Now, Clore was the beneficiary of a family trust which was of very considerable value. And under the trust instrument, the money was to vest in Clore when he reached 30, and there was a power to advance up to 2/3 of the trust capital for the benefit or advancement of Clore when he reached 21. So the trust instrument said that the trust capital would vest in Clore when he reached 30, but the trust instrument gave the trustees a power to advance up to 2/3 of the trust capital to Clore when he reached 21. Okay. This also demonstrates you can put rules on the power to advance in trust instruments. Okay, the trust instrument will of course trump statute and case law. Now, Clore wished to give 7% of the capital of the trust fund to a charity established by his father, who was also the settler. So Clore wanted an advancement of the trust capital to donate to charity. And in general, you should be thinking that courts love charities, but in this case, they didn't go with that decision, okay? So they said that he couldn't do this. And the judge here says that it seems to me that a beneficiary under a settlement may indeed, in many cases, be reasonably entitled to regard himself as under a moral obligation to make donations towards charity. The nature and amount of those donations must depend on all the circumstances, including the position in life of the beneficiary, the amount of the fund, and the amount of his other resources. So you must look at the whole picture of the beneficiary and see how that advancement helps them. Once that proposition is accepted, it seems to me that it must lie within the scope of a power such as that contained in Clause 8 of this settlement, for that is the trust instrument here, for the trustees to raise capital for the purpose of relieving the beneficiary of his moral obligation towards whatever charity he may have in mind. If the obligation is not to be met out of the capital of the trust fund, he would have to meet it out of his own pocket, if at all. Accordingly, the discharge of the obligation out of the capital of the trust fund does improve his material situation. So what was happening here was that Clore's father really wanted him to donate to charity, but he was broke, so wanted an advancement so he could donate to the charity. And he felt that if they didn't make such an advancement, he would be morally obligated to donate out of his own pocket. The court said that in general, they do not want to cause a detriment to the beneficiaries and will help them out, but ultimately the court decided this moral obligation to the charity was not a worthy advancement. So a moral obligation might be enough, but in this instance it was not. Okay, and we've also got the case of Marquess of Abergavenny. And it says here that for pre-2014 trusts, the money cannot amount to more than half the capital. If the capital grows as a result of an investment, the beneficiary cannot apply for more. So what this means is that you can get up to 1/2 of the capital for pre-2014 trusts, as we said previously. So let's say you get your advancement of half the capital, the max you could get pre-2014. Then a week later, the capital grows substantially. For example, there's a rise in the stock market. You cannot subsequently ask for more capital. That is another advancement because of this subsequent capital growth. In other words, it's too bad that you already got your advancement. You cannot get another one. Taking account of past advancements gives him his half presumptive share in his capital interest. He may no longer be advanced any funds, regardless of how much the value of the capital increases in future years. So you cannot get another advancement if capital has subsequently increased since you received your half share of the capital, as the limit was when this particular case here was decided. And this is the case that establishes that. And the potentially final case, no, 2 more cases now. So Pilkington and Inland Revenue Commissions is another case, and this is a case about the Pilkington family that made a fortune out of glass. And here the testator left money in trust for the benefit of his nephews and nieces, that is the beneficiaries, and on their death to their children, so they had a remainder in trust subject to a power of appointment. Now the trustees wanted to advance half of the capital, to which one of the children, then aged 5, would become entitled on her father's death. So what the father, that is the beneficiary of the remainder child, wanted to do was to set up a new trust for his daughter. And the trustees had a power of appointment, and this allows the trustees to give property to someone who will become entitled to it in the future. And this was an express power in the trust deed. So as long as the life beneficiary is okay with it, the trustees can give some up to half of his trust money to a future beneficiary. In other words, the trust said that the daughter would be entitled to the trust capital when her father died, but the power of advancement meant she could get it up to half of the trust capital before her father died. Now, the advanced capital was to form part of the funds of a new settlement, okay? The beneficiary was okay with the advancement, so money from the trust fund was to be advanced to settle a new trust for his daughter, who was 5 at the time. So the plan was to take the money out of the trust capital and use it to set up a new trust for her benefit during her lifetime, and for the benefit of her children. The transfer would become exempt from death duties if the father survived for 5 years. So this was a tricky way of using an advancement to keep a trust going by avoiding the rule against perpetuities, and would have enabled her to avoid paying some taxes, so death duties. Now, although the House of Lords held that the scheme was void for perpetuity, as the perpetuity period should commence at the date of the first trust, at which time the child was not a life in being, they held that the proposed advancement was allowed within Section 32 of the Trustee Act 1925. So, because the new trust was born out of the old trust by using money from that trust, the perpetuity period was taken as from the establishment of the old trust. In other words, the House of Lords said that the perpetuity must commence from the formation of the original trust and not the new trust. So you cannot create a new trust out of the old trust to get around the perpetuity rules. As the daughter was only 5 years old and not born when the father's trust fund was set up, she was not a life in being, so the trust failed. It was void for perpetuity. So the money then went back into the original trust. The reason was that there was a possibility, or rather a probability, that the daughter would outlive her father by more than 21 years. In which case the perpetuity period, and it was his life that founded the original perpetuity period, would be exceeded. However, the child was entitled to the advancement. Okay? It should be noted that the child was entitled to the advancement despite the fact that her interest was contingent on a number of events. That she could reach the age of 21, that she could not die before her father, that the trustees should not exercise their power of appointment or their power to make over the trust property to her father. Furthermore, the extent of her interest would be affected by the birth of further children to her father. So this case doesn't make a whole lot of sense, really. Any payment made under Section 32 will be taken into account when the capital is divided. The trustees should take into account the interest of other beneficiaries, and we should see Section 32, subsection 1c. And the very final case I want to look at before finishing this rather long video, but necessary video, is pooling settlement trust. And the father of the beneficiary of the trust prevailed upon them to apply to the trustees for payments from the trust capital. These payments were used by the father to fund his lifestyle and pay his debts. So in this case, the bankers Coutts & Co. were trustees of a fund which was held on trust for a wife for her life, with a remainder on her death to her children. The trust instrument contained an express power for the trustees to advance to the children up to 1/2 of their share with the consent of their mother. The husband of the life tenant, who was the father of the children, lived beyond his means. In other words, he was in debts and needed his lifestyle funding. And he sought to obtain part of the trust money by means of advancement to his children. So remember that money being advanced to a child will be held by a parent to exercise its payment for the child. But here the father, having received the money that was advanced to the children, decided to spend the money for his own means. A series of advancements were nominally paid to the children, but the money was used for the benefit of their father, or generally for the family. The court found that the trustees were in breach of their duty as they had not ensured that the power was used for the advancement of the children. So to obtain advancements other than for the benefit of the beneficiaries would not be a proper advancement. Okay, so that is the end of this video on advancement, and actually the end of our videos on the particular powers of trustees. In the next video, we're going to move on to talk about variation of trusts. But if you have any questions about this particular video, then please leave a comment below and I'll get straight back to you. If you enjoyed the video, then make sure you give it a thumbs up and subscribe to my channel. Thank you very much for watching.